An update in the case of former National Security Advisor Michael Flynn, who pled guilty late last year to lying to the FBI in the special counsel's investigation into Russian meddling in the 2016 election. Shortly after that plea, Judge Emmett Sullivan took over the case and ordered Mueller's team to share any evidence it has that could exonerate Flynn. Sullivan issues this order in every criminal case he handles. So what does this mean for Flynn? With us now are legal eagles Bob Bianchi and David Bruno, both criminal defense attorneys and former prosecutors. Gentlemen, good evening.
Good evening, Mike.
So, Bob, is the Michael Flynn case unraveling?
No, it's not unraveling at all, because you have to remember with Flynn in particular, there are also a lot of state crimes that he could potentially be looking at. He got a very favorable sentence with the federal government. So I know a lot of people are talking about, well, President Trump could pardon him, but he can't pardon him for state crimes like kidnapping, assault, wire fraud, and things of that nature. So based on that beneficial plea offer he got, he would be crazy in my mind to withdraw his plea. This is a standard thing the judge did. It's not going to change the facts and circumstances. It's not going to have any effect on the case.
David, my guess is folks at home are saying, how can you plead guilty and then say not so much? Your thoughts?
Yeah, sure. I mean, generally speaking, when people plead guilty, the judge goes through this document in painstaking detail that you're doing so knowingly involuntary. And in his specific plea agreement, he also agreed to waive any further discovery at the point of the plea. So I agree with Bob. If he takes back his plea, then the federal government can prosecute him for all the crimes he's already pled guilty to, among others. Not a good move for the Flynn team.
Bob, what does Flynn's legal team say that essentially some of this evidence that's been uncovered is beneficial to his case?
No, I mean, we don't know right now. What they're basically saying is that the prosecutors, federal court's different than state, and actually they have a great advantage because a lot of times you don't get all of the data and information. As a former prosecutor in state court, it was a lot harder, but now as a defense attorney, when we walk people into federal court, we basically don't know what it is that they've got. We do a proffer session or a queen for a day, as you've been hearing lately, and then basically if your client says to you, look, I did this, and we think the government has the evidence, you know, we got to start playing ball with Team USA. But a lot of times we don't have all the reports like we do in state court. So I don't think that the lawyers are doing anything other than saying, Mike, stick with this because this is 0 to 6 months right now based upon the acceptance of responsibility reduction credits you got. Right. That's a fancy way of saying for cooperating, don't blow it. And also don't hurt your son.
David, what does the government say that this information is not material to the case? And by the way, he pled guilty?
Yeah, that's generally the position. However, on Friday, Judge Sullivan amended that order to say that the government has to provide any favorable evidence during the course of the plea negotiations. So that is different from the December order that Sullivan signed. So right now, the government is going to have to go back through all of its files and determine whether or not something is favorable that hasn't been provided. One additional point, Sullivan's order says, government, if you think something is favorable or maybe not so favorable, give it to me. I'll review it, what's called in camera, away from the attorneys, and I'll make the decision.
Bob Bianchi, David Bruno, we have to leave it there. Gentlemen, thanks very much for staying up late with us.
You got it. Our pleasure.
Pleasure, Mike.